Good morning, everyone. Welcome along. I can see people arriving. Oh, excellent. There we go. We can see the people are arriving. It's nice to see you all this morning. We'll get started with some introductions in just a second. I can just see the number of people going up and down, so I just can tell there's people arriving and coming into the meeting. So welcome along. This morning we are talking about the Worker Protection Act, 1 year on. Big piece of legislation came into effect last October. We're about a week late, I think, aren't we, from the deadline? But a year and a week on. It's nice to see you all here this morning to talk through what impacts we've seen, what changes have we seen since the Worker Protection Act came into effect last October. So let's start with some introductions. I'm Heidi. I know there's a lot of people on the call that know me, and there are lots of familiar names. And welcome along. Hi, it's really good to see you all. To anyone I don't know. So I work at Reality HR, background in HR as a generalist, but for the last 7 or 8 years, I've really been specialising in learning and development. So I spend a lot of time doing management and leadership training. But because I don't mind speaking in front of roomfuls of people, I also get nominated to deliver lots of these type of webinars. So you may well have seen me on calls like this before. But I've never worked with Alice. So I'm going to hand you over to Alice to introduce herself.
Morning. Nice to meet you all. I'm Alice. I'm one of the solicitors in the team at Herrington Carmichael. I get the privilege of speaking to you this morning about the Worker Protection Act. We are seeing a lot more in terms of sexual harassment. There's obviously a lot of changes coming through in terms of workers' rights at the moment, and I sort of deliver these sorts of things quite often. So yeah, should be a good hour.
Hopefully you all know who we are. We'll share the slides afterwards. I don't think we need to spend too long telling you about our respective companies. I think we've got lots of people on the call who have been working with us both for a long time. So if anyone's got any questions, obviously get in touch with us afterwards. So today's session, what are we looking at? Well, the Worker Protection Act is all about sexual harassment, as most of you will be fully aware, and the enhanced duty that's been placed on employers. So we're going to recap what that means, what that looks like, what's been happening for the last 12 months. We're going to take a legal and a HR perspective. We're going to talk, Alice and I are both going to talk about our experiences, our company experiences, about what's been happening out in the world over the last 12 months. We're going to talk about what changes are coming with the Employment Rights Bill. As Alice just said, we've got lots more change still to come. So we'll be making sure, talking through how you can make sure you're prepared. Are you doing everything you need to right now? And are you ready for those significant changes that are coming under the ERB? So we will close with some sort of practical next steps. Now, those of you that have been on any Herringtons or Reality webinars in the past know we're really, really informal. We will probably interrupt each other quite a bit. We'll talk over each other because, you know, that makes for more fun. But actually what I mean is that if you guys have got any questions, please feel free to put them in the chat. Don't feel like you're interrupting and don't feel like you've got a silly question. If you've got anything at all you want to share or ask, we're really happy to take that and bring that into the conversation. As Alice says, we've got an hour's worth of conversation to have between us, but it will be much more interesting if you guys want to get joined in as well. Now, we are recording the meeting and the recording will be shared afterwards. We are also going to share the slides, so don't worry about taking millions of notes, unless, of course, you want to. There's no tests at the end, though, so you're not revising for exams. You'll be pleased to hear. So let's get going then. Alice, I'm going to hand straight to you to talk about what did the Worker Protection Act mean? What did it bring in this time last year?
Cool. So yeah, like Heidi said, this came into force in October 2024, and obviously this was a really big deal. What we're looking at today is sort of what's happened over the last year in the midst of all of these other sort of reforms to workers' rights. But I think it's probably good just to take stock, have a recap as to what the actual duty is, just to, you know, remind ourselves. So under the Worker Protection Act, employers have a legal duty to take reasonable steps to preventing sexual harassment at work. So that's not just by other employees, but by third parties. So think, you know, clients, customers, contractors, anyone that your staff interacts with. And this isn't just, you know, a box to tick. This duty's preventative, not reactive. So it's not enough to deal with issues when they arise. You're expected to anticipate risks, mitigate them, and create a culture where sexual harassment is less likely to happen in the first place. So think of it as a shift from, wait until something goes wrong to show me what you're doing to stop it in the first place. And if an employment tribunal finds that an employer hasn't done that, then they can increase compensation by up to 25%. So you've obviously got to think, as well as in addition to the financial risk, it's about reputational and cultural damage too. And these things are all over the news when they come out. And you've got to remember that employment tribunal judgments are public records. So anyone can access them. If it did go wrong and you did potentially lose a claim in that regard, they could potentially see the written reasons for the judgment. So in terms of, what this duty is, the question isn't in sort of practical means. It's not, do we have a policy? It's, can we show that our policy actually works in practice? There really is a lot more thought that goes into this sort of proactive duty. And to that extent, we've seen a lot of organisations focus on the policy update, which is brilliant and is something which is needed, which we'll speak about a bit later. But that's just step one. The real challenges are, embedding this into the day-to-day in terms of that proactivity. Do people trust your processes? Are your managers confident enough to, step in early? Those are questions which are now going to be addressed in terms of whether or not you have taken those reasonable steps to preventing it. So in terms of, what sexual harassment is then, I appreciate many of you or all of you will be very well versed in the legal definition of sexual harassment, but I think it's always good just to remind ourselves. So under the Equality Act, sexual harassment is unwanted conduct of a sexual nature that has the purpose or effect of either violating someone's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. So it could be an inappropriate joke, a comment about someone's appearance, a message on Teams, or it could just be an atmosphere that feels really uncomfortable in terms of that sort of environment. Now, a few, key parts of that, I guess. So unwanted obviously means unwelcome, uninvited. The person doesn't have to say stop or make a formal complaint for it to, count as sexual harassment. And in terms of the conduct, it can be verbal, non-verbal, physical. It doesn't even have to be, physical contact. It could just be comments or gestures, messages, or imagery. And it doesn't need to happen repeatedly. A one-off incident, if it's serious enough, can absolutely qualify. And it's all about impact and not intention. So even if someone didn't mean to cause offence, it's still harassment if the effect was that the other person felt degraded or humiliated. And the key here is that the unwantedness of this means we're really looking at the nature and the impact on the employee rather than the intent of the perpetrator, so far as the effect is reasonable. So that's what we really need to bear in mind when it comes to looking at, what it is from a legal perspective. And it's a broad definition, and, that's deliberate. It's designed to reflect the many ways harassment can show up in the workplace. So in terms of what that means then, I've highlighted on the next slide a sort of few areas that we often get asked about in terms of these situations where they come up. So these are things which sort of in the sort of grey area, the more nuanced questions, rather than just a really clear black or white. So does it count if the person didn't say anything at the time? Yes. Unwanted means, unwelcome or uninvited. They don't need to object in the moment for that to, to then be able to, completely disregard it. If it was just banter, we all know that is not a defence. The test, like I said, is how it made that person feel, rather than what the perpetrator or the speaker intended. If it was just once, does it still count? It can do. Like I said, if it's serious enough, that single event can count as harassment. It doesn't have to be a chain of events necessarily. if everyone laughs about that sort of thing here, it's one that I've heard a lot. It doesn't matter if it makes someone uncomfortable, you know, it is a problem that needs to be addressed. If you're saying, you know, but oh, they used to be okay with it, why not now? People can change their minds. We all know that past acceptance doesn't mean permanent consent, and so that is certainly something that wouldn't come into it in terms of a defence to that. What if it wasn't directed as that at them, but, you know, just overheard? Still counts. If it was, you know, making that hostile working environment for that person. And in terms of, you know, aggravating factors, absolutely these come into account. You know, power dynamics, previous warnings all make it far more serious. Essentially, it's not about debating what is offensive enough. It's about whether you've created a culture where people feel safe to speak up before things escalate. So at that sort of having a speak up culture within your workplace is something that we all need to be working towards, and it certainly goes towards those reasonable steps. So what are the reasonable steps then? This is the $1 million question. What exactly are they? The short answer is there's no single checklist. There's no specific legal definition. The law deliberately leaves it open because what is reasonable really does depend on your workplace. It depends on your size, your sector, your risk profile. I think sort of taking all of the guidance and all of the sort of commentary and the legislation into account, the goal in terms of taking those reasonable steps is practicality and proportionality. So if you've done all of the practical, proportional things that you can do, and you've documented them, you know, you've probably got solid ground there in terms of having taken those proactive steps. But really, in terms of what they look like on a practical level within a workplace, rather than through sort of written guidance and written commentary, is going to be evolving over time, and you know, it'll become clearer as we see case law evolve through the tribunals. What we do have, however, is guidance from the Equality and Human Rights Commission, which demonstrates what this involves, and Heidi's going to be taking us through that in more detail. But you know, think policies, regular training and engaging training, sort of like this sort of style, not that e-learning one that you just sit and click through. Cultural sort of top-down approach and things like that. But I'll let Heidi go through that in more detail. But if you're a larger or higher risk employer, you know, say hospitality, retail, construction, your bar is higher. So you're going to need to be showing active prevention, not passive compliance. And these are all, you know, this is where the regularly looking at these steps, regularly checking in from an organizational perspective on, you know, what steps you're taking, how these may need to be revisited is really important. Now, when the Act came out, there was a lot of talk about third-party harassment and looking at that. So, looking at it, it's one that's caused a bit of confusion, and this is just in terms of sexual harassment and the third. Sorry, I'm just watching these questions come in. We'll just pause there because there's a couple of questions that I think I've lost the question thing. In terms of construction, it's not necessarily that that the bar is like that the legal bar is specifically higher. It's just in industries where you have higher risk than others, it's going to be really looking at the steps that you can be the steps that you will need to be taking in real detail, and you'll, because naturally where there are higher risks, so I work a lot in the hospitality sector, and where you have a lot of client interaction in the same way that potentially, you know, in construction there's a lot of third parties involved and things like that. We'll get to third parties in a minute, but it is potentially higher risk than other sectors, if that makes sense.
So it means that you're going to need to take more actions. So
Yeah.
in an office environment like Alice works in or I work in, we're an open plan, well lit office with maybe 20 people on site, and that's a very low risk environment. So the actions we need to take to be, what was the phrases, Alice? Proportional and
Yeah,
reasonable.
yeah. So practicality and
Practical.
proportionality, they're the ones
We
that I like
we
to.
don't have we don't have very many that we need to do because actually the risks are quite low. But in somewhere like construction, those risks are much higher because our workers are coming into contact with a lot more third parties, for example, and in hospitality, they're coming into a lot more contact with members of the public and potentially members of the public who have been drinking. And when we know that when there's alcohol involved, the risk increases dramatically. So I hope that answers that question, Catherine. It's not a specific industry per se, it's the risks associated with working in that industry.
Yeah, yeah, because I think in terms of third party harassment, it is something that's caused a little bit of confusion when it came in, because the original plan when the Worker Protection Act was originally drafted was for the act to create a specific duty around third party harassment, but that was dropped. So even even so, I guess even with that being dropped, the EHRC guidance makes it really crystal clear in terms of the preventative duty, still applying to anyone. So not just colleagues. Harassment by third parties, I'm sure you can appreciate, it can be just as devastating for a worker as harassment by a fellow colleague. So like we said, like Heidi said as well, if your staff or workers are exposed to customers, clients, service users, contractors, you need to show that you've taken reasonable steps to protecting them. So that might mean about having a policy about, customer behavior, training staff on how to handle incidences, and making sure that they can report things really clearly where that is that higher level of third party interaction, because ultimately the message from the government and the EHRC is, it's simple. It's that employees and people at work should be protected from sexual harassment at work, no matter where that comes from. But as it stands, there's no separate specific duty around that third party harassment. There, I'm not sure if that answered the question. Sorry, my chat
There's a
box
second
keeps
question.
going.
No, that's fine. There's a second question around subcontractors. So just to pick up on that, then the question says, should we then need to include our subcontractors in any training we do? So there's the first part of the question. Alice, what would you answer to that one?
I mean, I think you'd look at whether that's practical or not to do. I would focus on having it within your for your employees and for your staff, and then in terms of how they then interact with those subcontractors there. I'm not sure what
The
your thoughts.
training and focus is for your employees. And then the second part of
Yeah,
Catherine's question, I think you're going to smile more at, Alice, because it says, or should we check with the subcontractor's company to check they do the training? And we're both nodding because
yeah.
Catherine, that would be our advice, very much so. You
I
don't
think
necessarily need to train everyone who comes onto your site, but you do need to make sure that they have been trained, probably by their employer, in as far as it's reasonable for you to do so.
yeah, and it goes down to those. I mean, as it currently stands, we have to caveat that with the changes that are coming under the Employment Rights Bill, but it does go down to those, the reasonable steps that you can take to protecting people in your organization. So really looking at, okay, well, how can we protect them then? What is our approach going to be? And is that reasonable in the circumstances there? So yeah, I think Heidi, you were going to look at the guidance now, weren't you?
Yeah, before we move on, should we just go back? We had a question that said, does all of this that we've covered so far relate purely to sexual harassment, or does it apply to other forms of harassment as well? For example, racial harassment. So should we just answer that one, Alice, before we move on?
This is just looking at sexual harassment under the Worker Protection Act.
So if we go back to the recap of the Worker Protection Act here, the points that highlighted about third parties and prevention absolutely just apply to sexual harassment at the moment. But the definition of harassment, if we look at it there, if we just took out the word sexual, it's pretty much the same then it's pretty much the definition of all other types of harassment, isn't it? So we then as employers are responsible for fixing it if it happens, rather than the preventing, because the preventing at the moment only applies to sexual harassment.
I think, agree. I've just seen Sharon's question come up. I think we need to look at a risk assessment in those instances. So this is one of the things that Heidi's going to speak to, and it's all about risk management, and that's the sort of starting point for this. So where I appreciate I don't want us to sort of go through what Heidi's about to say, but
Fine.
I'd say in those where you're the question of reasonableness, it starts with, okay, let's evaluate the organization, how it works, where do our risks lie, and then we take that into account in terms of what we can do to reasonably prevent that sexual harassment from taking place.
One of the things that we often talk about when we're looking at this use of subcontractors or having subcontractors coming onto our site is to consider, what would you do from a health and safety perspective for those guys? So where you're letting a subcontractor come onto your site to do some building work, for example. You're not a building company, you're an office, but you're bringing a building company in. You would often make those guys sign a health and safety statement to say that they know I don't know, whatever you're going to tell them. And so what you're going to tell them about your building, but also your expectations of them back towards you. And there is a suggestion that you might have some sort of sexual harassment or harassment policy that they are expected to sign. And that would work to Sharon's question here about what if they're only a sole trader and they don't have a big HR team or legal team at the top? Well, that would be the same thing, maybe a light touch, not necessarily training, but a light touch statement, like you'd have a health and safety statement available for your business. Could you have something around dignity at work or harassment statement?
And in terms of how it works in hospitality, like I said, I work a lot in the sector, and I think there's different ways that it's being approached. Some organizations are having in each of their properties have sort of signs that say that we don't tolerate any harassment of any form, including sexual harassment. I appreciate that sometimes you don't want that plastered on all the walls, so a lot are doing it in terms of where you're booking things on a booking system. They're just having a sort of paragraph that says, where you're booking in terms of that property or that sort of going out for dinner, then you have the line that says, we are we're a zero tolerance organisation to it, and we just have a zero tolerance approach to sexual harassment. So that's sort of the things that we're looking at in terms of the interaction with the public.
And I think this is where we come back to your point from earlier, Alice. It's all well and good writing those signs on the walls or putting a statement in your booking forms. And that's one tick, that it's important that you've done those things. But then what's really actually important is that you live and breathe those behaviours. So if someone does come on, someone's booked onto it, let's say to a dinner event, they've as part of their booking, they've seen the statement that says we're a zero tolerance. We have a zero tolerance attitude to any misdemeanors, misbehaviour to our staff, and we'll protect our staff's dignity at work. Then on the night, that person's maybe had too many drinks and is being inappropriate with some of the staff. Do you ignore it and just put it down to hijinks and banter and drunken customers, or do you actually follow up on you saying, we said we're a zero tolerance organisation, so actually what we're going to do is take action immediately to exit this person. We're going to ask this person to leave or ask them to change their behaviour. So it's not just what you've put in writing, which is also obviously important, but it's actually how you live it then in the reality, which is going to be your defence if you ended up in a tribunal. So. Or lack of defence. And that's really what the 8-step guidance from the Equality and Human Rights Commission is trying to get to. It's about making sure we've done the paperwork right. So we've spent the time thinking about this. And I think you said that earlier, Alice, this is something that we have to be able to show we've actually really thought through. So the EHRC very helpfully gave us these 8 steps, which is great guidance, but they not very helpfully numbered them 1 to 8 in a system that doesn't actually make much sense in my mind. So let's start with number 3. If you haven't done a risk assessment yet, number 3 should be your starting point. And as Alice just said there, this is looking at what type of environment do your staff work in? Is it a very well lit open plan office, like my example, or is it a building site? Is it hospitality? Are they out traveling? Are they out lone traveling? Where are they? Where are the risks coming from? Which type of third parties do they come into contact with? Are they likely to be at particular risk in any of the circumstances during their employment? So that risk assessment is the very first port of call, and you need to get this in writing. You're probably all thinking it. You probably, I'm sure there are lots of you that would be like, oh yeah, we don't ask our staff to get a tube, we pay for a taxi, or whatever, because you've thought it through. But have you documented it? Get that written down into some sort of risk assessment or risk matrix document. And then once you've identified all the possible risks to your staff, you need to then work out, what is it reasonable for us to mitigate? How can we reduce those risks as far as is practically possible? That doesn't mean stop running your business. It means reduce the risks while balancing that with the needs of still running your business. And that's where the different levels of reasonableness come for different size organizations, because a bigger company probably has more resources to do more than a smaller company, for example. Once you've done that risk assessment and worked out what your mitigations are likely to be, put that into some sort of policy and publish it. So make sure your staff know, firstly, their expectations, that they're not allowed to harass each other. And I deliver a lot of dignity at work training, and I quite often open it by saying, look, this sounds really silly, and I'm going to stand here at the front of the room and I'm going to tell you not to harass each other. And everyone laughs, and I think, well, we obviously still do it though. It still happens regularly, because otherwise Alice and I wouldn't be in jobs. It does happen. We know it still happens, and it just sounds so silly, but this is what part of the purpose of the policy is, to remind everybody of their responsibilities to treat each other with respect. The second part is to remind everybody that we will look after their well-being. We will prevent and stop any harassment should they come and talk to us about it. And we want to encourage them to speak up and talk to us about it. And that's a big change, really, I think, that came about with this EHRC guidance from how it was before. That actually we really are encouraging people to share, speak up, talk about their experiences, so that we can be more proactive about making sure that doesn't happen again. So risk assessment, write a policy, share your policy, engage with staff through publishing policy, through training, through methods like surveys and exit interviews, to understand where actually people are feeling that there are risks. So it's all well and good you sitting in your ivory tower and writing a risk assessment, but actually, what do your staff think? Where do they see risk coming from? Have they experienced or witnessed any forms of harassment in your workplace? And engaging in that way and inviting people to share their experiences can be really powerful, because the number of companies we talk to that say, oh no, we don't have any sexual harassment in our company. Oh no, it's a really great environment working here. And I wonder how much that is actually the truth. They may not have had any sexual harassment complaints raised that they're aware of, but that's the point. Are they not aware of them? So I think we will probably all expect that just because you haven't had any complaints raised doesn't mean it's not happening. So engaging with staff regularly and in a genuine way to try and find out is really important. Clear and confidential reporting channels. So there are traditionally, most grievance procedures said, if you have a grievance, a concern about your employment, you should go to this one person with your concern. And we are absolutely encouraging people to broaden that out and make sure that people have a different route. Because what if that one named person is the one doing the harassing or is complicit in the harassment? So making sure there are a number of named people, a number of trained, confident and competent people that people can report to. And consider whether there's any sort of opportunity to do that anonymously. So some of you may have whistleblowing, external whistleblowing companies in place. And those can also be useful to share as an option for people to be able to raise a concern about sexual harassment confidentially. We use an app, an engagement survey app within Reality HR to pulse surveys, and there's a reporting option in that app that says I can report any concerns or suggestions to the company anonymously. Now, I know it's really hard, and when we talk about anonymous reporting, actually you'll all be thinking it, well, what's the point of anonymous reporting, because how can I fix it if I don't really know who it's happening to? But it is an option to think about. It can give you opportunities to investigate, check your policies. It's a great reminder that your policies obviously aren't working. So what else is it you need to be doing? Do you need to be going out and being more proactive about training and reminding people what the policy says? So even if you have an anonymous report, you can still take many steps after that. We've both mentioned training a lot. I think that this is about awareness for staff, but it's also about awareness for managers. Are your managers confident, comfortable, competent to hear a concern, to look for concerns before anyone's even raised the complaint? Because this is also a big point. It's a big responsibility on line managers to be proactive in looking for where risk might be coming from, looking for where banter might be tipping over into something that's uncomfortable with somebody, where banter might actually be inappropriate in a 2025 workplace. So it's important that managers have really had good, bespoke, designed training, opportunity to discuss and debate as well. As Alice said, there are many e-learning options available. And if that is all you can do, then it's better than nothing. But it probably isn't bespoke enough to be a reasonable step, depending on the size of your business. So we would definitely recommend having that conversation with one of us about whether e-learning is a suitable or robust enough response for training. I think we've covered all the steps there. As I say, the EHRC guidance is really good. It's got all the things you need to think about there, just maybe not in the right order. So, sorry, there's just been a question popped in. So great question from Alice saying, in their company, they had a big launch of the Worker Protection Act policies and training earlier in the year, and all subsequent new hires have had in-person training as part of their day one onboarding. Very big tick there, Alice, for that. That's a great start in that first year. Now, the question is, should we be considering follow-up training? Yes, absolutely, because your policy will probably say something like, we will provide regular training to our managers and to our staff. And for those of you that were on the ball this time last year, you're now a year later and you might be thinking, is that time for a regular refresher? Now, the regular refresher can be in a number of different ways. Alice, you've asked there, is requiring all staff to reread the policy likely to be sufficient? It's a tick, as is a e-learning. You might decide that that's enough this year, and then next year you want to do something a bit more in depth again. So you have a sort of a cycle of light touch, bit more in depth, light touch, bit more in depth. That's a great way of looking at it. You might decide that e-learning is right this time round, and send everybody just to go and sit at their computer and do their 30 minutes watching the videos and answering the quiz at the end. As a refresher, that's probably a great thing to consider. You may decide that you want to do some live trainer-led webinars like this, where you get people on, because then they have the opportunity to chat and discuss, which as a L&D professional, I would always say that the conversation is where people take the value and where people remember training. But I appreciate, again, we've got to look at what's practical and what's reasonable in each organisation. So if you did a big round of face-to-face training a year ago, you might decide that you don't want to do face-to-face trainer-led now. You're going to do something lighter touch now. And then maybe next year you go back to another round of face-to-face. Alice, would you have anything different to say on refresher training?
No, I think it makes sense. I think we're doing a lot of refresher training at the moment. So we are doing it at sort of all staff and also where they're sort of exec level training, just to have that sort of check-in a year later off the bat, because again, where organisations are wanting to be proactive on this front, then that's where that refresher training comes in. Just again, like we're sort of drilling down on it, is living that policy out. So it's not just signing the policy again when you do sort of your handbook updates at the start of the year. It's really putting aside that time to invest in that.
That's a really good. If you look at number 8 on the slide there, it says monitor and evaluate the effectiveness of your actions taken. Now that could be at exec level, senior team level, a really good opportunity to do that sort of refresher training and combine it with a review of what's been happening. Let's evaluate, let's look at our data. Have we seen an increase or decrease in number of grievances or number of harassment complaints? Have we seen an increase or decrease in our engagement survey scores? What's the anecdotal feedback we're getting from people? What have people said in exit interviews during this past year? So now let's go back and look at our risk assessment again and see if there's anything else we can mitigate to reduce this risk any further. So that would be a really good opportunity to sort of a bit of a line in the sand to say, right, we've been a full year now, let's review, but also let's make plans for the next year. I think that would be a really good way of recording that you're doing that monitoring and evaluation piece, and you could combine it with that refresher training for your senior teams. Okay, good. Hopefully we're answering questions as we go. We'll keep an eye on those as we continue. Any other questions, please feel free to pop them in the chat. So what has been happening? What's been going on in your organisations? I'm going to see if I can manage the technology now and make a poll work. I'm curious to know if in the last year since the Worker Protection Act came into effect, have you guys in your organisations seen an increase in sexual harassment complaints? It's an absolutely anonymous poll. No names are recorded. I'd just love to see your views. Has it made a difference to the number of sexual harassment or maybe more broadly harassment complaints in your organisations? Okay, so I don't know if you can see the responses there. I can see that there have been 18 of you reply, 6% saying yes and 94% saying no. You haven't seen a particular increase in sexual harassment complaints. Now, you might need to just press X on that one, close that one down, because I was just going to ask you another quick question before we move on. Have you experienced an increase in grievances in the last 12 months? Curious to know about number of grievances to see if it matches our experience as a HR consultancy. 20% have said yes to this one. So 20% of you on the call have said yes, you've seen an increase in grievances. 80% still saying no. Okay, interesting. We have definitely at Reality HR seen an increase in grievances. Not specifically around sexual harassment, but definitely an increase in bullying and harassment concerns raised. Dramatic increase in the last couple of years. Probably not necessarily exactly the last 12 months, but across the last 2.5 to 3 years, I would say we have seen a dramatic increase in the number of grievances that we're being asked to support our clients with, to advise on, and in fact to hear ourselves. I've been at Reality HR for 14 years, and I think for the first 10 years I was there, I probably was involved in maybe 2 grievances in 10 years, and now we get two a week, some weeks. So it's a absolutely exponential increase in the number of grievances that we're seeing happening. Why is that increasing? Awareness, maybe. I would definitely say people are more aware of their rights. It's more spoken about, it's more public. We've got TikTokers giving legal advice. I don't know how accurate their advice is, but they are making it a much more accessible topic for people. There are countless accounts out there across social media sharing stories of bad employers, people talking about their experiences and encouraging others to speak up, which, as I said, we want. That's part of the Worker Protection Act. Part of the ethos behind the Worker Protection Act is to encourage people to speak up so that we can actually take action to reduce it. So it's not necessarily a bad thing that the number of grievances are going up, because actually what it means is that we're able to resolve them, fix them, and hopefully prevent them from happening to anyone else in the company. It does obviously mean it's a big workload. It's looking bad. The data looks bad if you track the number of grievances, but actually from a practical point of view, that's not necessarily a bad thing. What we are noticing, I'm sure Alice is going to echo this sentiment, is that an awful lot of the grievances we're asked to get involved in could have been resolved informally if managers had noticed or addressed the issues much sooner. There has been a bit of a trend, I think, for people to jump into raising a formal grievance, partly again through this awareness. Now, we did have some question raised. Do you think people are writing more grievances because AI will write it for you now? So we've had a series of grievances from different companies that sound surprisingly similar. And we wonder if Grok or ChatGPT are writing them for people. So people are plugging in, these are the issues I've got at work. Write this into a grievance concern for me, a grievance complaint for me. Alice is nodding. Oh, she got similar experience, Alice. We haven't talked about this. This is a surprise for each of us, this bit of the session.
Yeah.
Yeah.
I think it's what I like to refer to it now as AI fueled litigation. And there are certain trends, including phenomenal numbers of data subject access requests, which are these trends that we're seeing through ChatGPT. You know, we can see ChatGPT all over something as soon as it comes in, and it's just it's
you can
certainly
hear
changing.
it the way it's written. You can hear it, can't you?
Well, equally, when you know the employee, you know exactly what their tone is, and you can see that that's not reflected in what they're putting to you as the employer. And so I think certainly there are some things which it's a real changing landscape in terms of what that looks like in this context as well.
And I think that from a HR perspective, our advice is to encourage managers to be on the lookout, always looking for these potential issues to resolve them before they become these formal AI written grievances. And I know it's easy again for me to sit here and say that, and it's not so easy to do in real life, but this is going back to the point Alice was making earlier about the difference between just writing a policy and living and breathing that type of culture, and encouraging people to have face-to-face time with their managers, so one-to-ones, and managers having this open door approach, this, you know, please talk to me, please come to me with any questions, you know, this whole culture where we're actually going to ask people to speak up and take things seriously, look for issues, look to proactively resolve issues. All of those things could prevent some of these grievances from actually becoming grievances. Now, some of it we can't change. People obviously have the legal right to put in a DSAR. They have the legal right to raise a grievance concern, of course, and we don't want to prevent people from doing that if there is a genuine concern. But actually what we're saying is there is absolutely opportunity to resolve some of these concerns informally. Even potentially once you've received a written grievance, by having that conversation with an individual and saying, what is it you're looking for as an outcome? Can we look at resolving this informally? You don't have to automatically move into a very formal solution, informal investigation. There may well be an opportunity for an informal conversation to find a resolution that satisfies everybody's needs. We would still say keep written notes of what you've agreed with them, go back and check in, make sure. But again, it's this proactiveness about going back and checking. We spoke a couple of months ago, you had some concerns. Is everything still okay? So you know what's happening. You're looking out for changes in demeanour. You're looking out for people looking unhappy, people not joining in the chat at the lunch break, you know, sitting in their cars at lunchtime. There's a classic indicator that someone's unhappy. So I think that's our key theme, is that we've seen a massive increase in formal grievances that we're being asked to investigate and advise on. But actually, when we start talking to individuals, what a lot of them want is just to be heard. And they clearly felt they weren't being heard by the management team before they put the formal grievance in. So that I think a lot of this could be alleviated by some more proactive, competent management. And you know, maybe I'm being unfair to some of those managers, but I do think that that's the themes we're hearing. Alice, how's it been from a legal perspective?
So I just wanted to, before I go into that, Jennifer, that's a really interesting question on how best to approach C-suite staff not completing their training. It's really a lot of this unfortunately comes down to sort of a financial cost benefit. And if we know that training is a reasonable step, and it's that the level of training, so that interaction, that time that they need to put into it, it's selling it on that front effectively and saying, look, this is what it could cost you if you don't do this, is an approach that you can take. That's one that we've certainly seen before. Equally, sometimes it helps to I know that we've done a lot of sort of separate C-suite training, so not necessarily the all staff training, but we would tailor that to the exec and tailor that in terms of what they need to be thinking about in terms of those steps versus obviously your whole staff team. It's a very different approach sometimes, so that's having a slightly tailored one might work, but I think I'm just looking at these questions coming in. In terms of if they are the costs and the ballpark figure, it's, you know, it depends on the harassment that's taking place. I think I can't remember off the top of my head the highest number that it was recently, but it was a significant sum without the 25% uplift, and that 25% uplift gets applied on every part of every other form of the discrimination claim as well. So it is monumental. It's not just isolated to that sexual harassment. But I think in terms of the providing the synopsis for the training, I think it's a really good step to take. In terms of what we have seen from a legal perspective, and sort of how we're getting involved, and when people ask us about these sorts of things, I think I've acted on both sides of this. So I've had a lot more engagement from employees who have unfortunately suffered sexual harassment in the workplace. Equally, I've been acting on defending claims involving with a sexual harassment element to it. So sort of both sides of the fence, there's definitely been an increase in activity. And equally, I think sexual harassment is, like we said, with you know, AI and AI fueled litigation, sexual harassment is one of those things that is now potentially, I think, an increase because of that increase in compensation across every part of the discrimination claim. So it's something that's can be tagged on to claim that uplift, you know, whether or not that would be successful or not. I think in terms of the sort of general optics of it, because it's much more in the media, and the I guess sort of the public interest and the sort of from that side of things and defending it in a public environment, because of all of those things, I'm seeing it being used as leverage in wider disputes and in terms of leveraging significant exit sums under settlement agreements. So it's really, really important that investigations are done on sort of both sides, so that you then aren't using that, or you have a good, if you're on the employer side, you've got a good sort of defence to those claims. I think in terms of a couple of other bits, ACAS saw a 39% rise in sexual harassment related inquiries, and that was just in the first half of 2025, so a lot more on that front. And 2024 analysis showed that harassment in the workplace is googled over 7,000 times a month, so the public interest is really high, and there is ongoing concern about it.
I wonder how many of those Googles were HR professionals going, what should I be doing to prevent sexual harassment in the workplace? But
I
that
think
was me quite a lot of the time when we were waiting for the detail around the Worker Protection Act to come out.
I think it's don't know where those sources will come from, but obviously it's something that's being looked at. I think in terms of employment tribunal claims under the Worker Protection Act, given that there is a monumental backlog in employment tribunal claims at the moment, we haven't yet seen sort of claims come through which are for sexual harassment and the reasonable steps under the Worker Protection Act. So we're yet to see how this will be approached, but because previously under sort of Worker Protection Act, reasonable steps were looked at in terms of the statutory defence that employers had to take to defend sexual harassment claims. So in that context, we can see that what would be looked at in terms of taking those all reasonable steps, but in in sort of a flipped manner. We've seen the steps evaluated to that extent, but not so much as a positive and proactive duty. And in this way, what I've seen is very recently there's been a lot of sort of high profile investigations which have come out into the public. So Lidl failed to take reasonable steps to preventing sexual harassment in the workplace, and they have now signed a legal agreement with the EHRC committing to their reasonable steps to proactively preventing sexual harassment because of this failure. So it's that sort of demonstrating, I guess, the proactive duty that they're committing to. In terms of the cases starting to come through, I would anticipate them being in over the next year or so. I'd say over the next 12 months, because we have got a vast backlog. I'm now getting claims listed for 2027, so I'd work on sort of a 12-month or so delay on that front. So obviously when they start to come through, when we start to see them, we'll be providing with updates on that front. I think, Heidi, you were going to speak about how to protect your business now.
Yeah, absolutely. Just before we move on, we've got a question saying, has the 3-month limit to submit an ET claim been extended? So while we're talking about timescales in employment tribunals, Alice?
Not yet. So there's a couple of changes coming up. So the early conciliation period is changing at the start of December, so that's now up, and the 3-month time limit comes in next year. In 2026, in terms of increasing it, I think it's going to be in October, and or currently under the proposals for under the Employment Rights Bill, but it looks like it's coming in the second wave of those amendments, and yeah, it'll be increased from 3 to 6 months.
Okay, right. Conscious of the time, I'm going to go really quickly because I think we've talked about a lot of this already. So protecting your business. Read the EHRC headlines, read the 8 steps of the guidance, and check you've done them all. In essence, is we've talked about all of these things: auditing and risk assessing your current position, making sure you've got the paperwork right, but that you've got a top-down approach, that your leadership, your SLT, your exec are actually leading this culturally and practically as well as on paper. So it's not enough for a HR manager to sit and write a policy and the directors to refuse to do the training and then refuse to change their behaviour. So that was a great question that someone asked about C-suite refusing to do the training, and Alice's answer was tell them how much it will cost when it goes wrong. It has to be.
It's a lawyer answer.
that was me paraphrasing your answer, Alice. Tell them what it will cost if they don't do it is always a good way to get through to those at the top. Your next steps are literally around those 8-step guidance from the EHRC. Check you've got your risk assessment. If you wrote it a year ago, fantastic. Go back now a year later and review it. If you haven't done it yet, please go and do that imminently, straight away. That's an urgent next step for you to do, is get that risk assessment done. Policy development. If you haven't launched a policy yet, go and launch a new policy. Get everyone to sign to say they've seen it. If you did it a year ago, again, it's now maybe a time to review it. Check if it needs a refresh. Have you added any new reporting mechanisms? Have you added any new data to it? Have you added any other risks that you've been identified in that time? So add anything that you need to and reissue. Yeah. Keep doing staff surveys and keep those open reporting lines and making sure you're reviewing the data that's coming through those. If someone in an exit interview or on a staff survey is raising a concern, make sure you actually embark on an investigation to look at what those concerns are. Even if it was an anonymous report through a staff survey, you can still go and investigate the culture in that particular team or environment, maybe. If you did training a year ago, well done. Refreshers due now. If you haven't done any training yet, please come talk to Alice or I after the session and we can talk you through what options are available. A whole range of lengths of time, duration, face-to-face, teams. We can make it work because practically we understand it has to practically work for your staff and your organisation. One of the key phrases in that EHRC guidance, I've given you the 8 headlines here, but there was 57 pages of guidance behind that. One of the key phrases that came through when they talked about training was that it should be tailored to your organisation, tailored to your industry, which is one of the real reasons that e-learning, you know, sitting and watching 30 minutes of videos and answering a quiz is unlikely to tick that box, because it's not bespoke in any way, shape or form. So talk to one of us, keep recording, keep writing it down, and keep monitoring how it's going.
Yeah.
I'm going to move on. We've got 5 minutes left, Alice, and I know you've got a lot to cover. Sorry.
Whistle stop talk. No, it's absolutely fine. What I just wanted to touch on, obviously, feel like at the moment we can't speak about any changes without talking about the Employment Rights Bill, particularly in this context, because whilst we spent a lot of time talking about what reasonable looks like, under the bill in October 2026, the positive duty is going to increase to all reasonable steps. That bar is going to go even higher, and this is likely to look at, you know, reasonable steps in terms of there being no further steps that could have reasonably been expected to take. So it's an absolute minefield. But it's really, this is why, if that's coming in, you know, October 2026, this is even more important to have in your organization. So I think in terms of, like we spoke about earlier, we spoke about sort of the context of tricky situations like, you know, contractors. I think, you know, at the moment, wouldn't necessarily recommend, you know, giving training to contractors. Give them a copy of your policy. Certainly that's a reasonable step, and, you know, reasonable in the context of contractors is going to be a lower bar than for employees. But I think in terms of looking at a tick box for the all reasonable steps, it might be, you know, things like considering, you know, contractual terms with any agencies to then add, you know, contractual obligations to them to ensure that anyone provided to your company has had some sexual harassment training. So even if the contractor doesn't do it, you are taking those reasonable steps in requiring it. So it's that sort of difference in that obligation. And I mean, that's just sort of thinking off the back of what's been spoken about with sort of third parties and contractors and that sort of context. In terms of the whistleblowing protections and NDAs, these, I've sort of grouped these. Obviously there's loads of changes and I am flying through and speaking at the rate of knots, but in the context of sexual harassment, these are ones that I just sort of grouped together because in April 2026 reporting sexual harassment is going to be explicitly covered under whistleblowing legislation. So that will mean employees have greater protection when speaking up. They can't have that sort of detriment as a result of that. And on top of that, there are proposals to limit NDAs in harassment and discrimination cases to ensure that victims of sexual harassment aren't silenced. So this is all heading in one direction, you know, more transparency, more accountability, higher expectations from employers. So that's why we say, you know, either starts to or continue to develop your culture now. You'll be ahead of the curve when it comes in, when these changes do come in. And you will be a much better place to defend a claim if it came in, or you know, better place to deal with it pre-claim, hopefully. So I think they're the sort of, that is probably the quickest rattle through of these changes, but those are the ones that I just wanted to flag to your attention now. I appreciate we are at 11 o'clock, but if you do have maybe time for a couple of quick questions, I don't know, unless you have got to shoot off. If not, then please do drop me or Heidi an email, or find us on LinkedIn, and we can go from there.
Absolutely. I think we've answered all the questions that were coming in as we went through the session. So if there's any other questions, feel free to throw them in the chat now, or as Alice says, get in touch with either of us directly. Anything about arranging training, policies, risk assessments, any of those questions that you might have, we are very, very happy to talk you through on a one-to-one basis after the session. We will share the slides, we will share the recording. And then you're very welcome to forward those on to any colleagues that couldn't make it today. Thank you all so much for joining us. We are at time, and we will wish you an enjoyable rest of your Thursday. Take care, everyone. Bye-bye.
Thanks.